Another gun safety law in New York is stirring controversy in the North Country.
Federal judge suspends key provisions of New York's new gun law.
The pistol permit owner decides to engage in a gunfight in Times Square. What are your chances of hitting an innocent bystander?
The judge said key parts of the law are unconstitutional, like banning guns from sensitive places like Times Square.
Lawmakers have failed to keep firearms out of the hands of people who shouldn't have them. So now their eyes are on ammunition.
Recall last January when the Supreme Court declined to intervene in a ruling by the U.S. Court of Appeals for the Second Circuit, allowing New York to temporarily enforce a new concealed carry law amid ongoing legal challenges. Justice Samuel Alito, along with Justice Clarence Thomas, issued a separate statement urging the challengers to return to the Supreme Court if the appeals court failed to expedite the resolution of the disputes. Now, this dispute has returned to the court's docket. 2 years ago, in New York State Rifle and Pistol Association v. Bruen, the Supreme Court overturned New York's previous concealed carry law, marking a significant shift in Second Amendment jurisprudence. The ruling made clear that gun restrictions can only withstand scrutiny if they sit well with historical regulations in the nation's heritage. However, the court did not specify the exact historical context courts should consider. In response to the Bruen decision, New York Governor Kathy Hochul called for an emergency legislative session to enact the Concealed Carry Improvement Act of 2022. New York's Concealed Carry Improvement Act. In contrast to the previous New York law invalidated by the Supreme Court, which required gun owners to demonstrate proper cause for a concealed carry permit, the CCIA imposes restrictions based on the individual's good moral character. To meet this criterion, gun owners must participate in a hearing with the licensing official and disclose various personal details. Additionally, the CCIA regulates where licensed owners can carry concealed firearms, expressly prohibiting them in sensitive locations such as schools, churches, and hospitals, and imposing limits on private property unless the owner explicitly permits it. Multiple groups of gun owners approached federal district courts in New York, seeking to block the implementation of the CCIA. They contended that the state disregarded the Bruen decision when enacting the new law, as it lacks any foundation in historical gun regulation traditions. In agreement with the challengers, the lower courts temporarily suspended various provisions of the law. Subsequently, New York Attorney General Letitia James appealed to the Second Circuit to reinstate the law while litigation progresses, a request that the Court of Appeals granted. Following the Supreme Court's rejection of the challengers' attempt to suspend the CCIA in January, the Second Circuit consolidated the lawsuits and expedited the schedule for oral arguments in March. In December, the Court of Appeals issued a 261-page decision that narrowed the scope of lower court rulings that had previously halted the implementation of the CCIA, stressing that its intervention occurred at a very early stage of the legal process. The Second Circuit determined that the challengers are likely to prevail in their argument against a specific provision of the law. This provision permits concealed guns on private property open to the public only if the property owner has explicitly consented, a measure deemed to infringe upon the Second Amendment, dismissing the state's attempt to justify this provision through historical precedent, such as 18th century hunting bans on private lands. The court reasoned to the CCIA's primary goal of public safety does not align with preventing poaching. However, the Second Circuit lifted the portions of the lower court rulings that had invalidated much of the remaining CCIA. This includes restrictions on carrying guns onto private property not open to the public, prohibitions on firearms in sensitive locations, and the majority of the good moral character requirement. The court argued that various gun regulations implemented after the Civil War, cited by the state, could potentially provide historical support for these other provisions. Consequently, The cases were remanded to the district courts for further proceedings. In the case of Antoniuk v. James, one group of challengers, led by New York resident Ivan Antoniuk, who holds a concealed carry permit, petitions the justices to review and overturn the Second Circuit's decision in the ongoing legal battle. They assert that the appropriate time frame for applying the history and tradition test as established in Bruin is the late 18th century, coinciding with the ratification of the Second Amendment. They argue against using the late 19th century, when the 14th Amendment was ratified post-Civil War, extending protections of the right to bear arms against state intrusion. The challengers argue that this issue is crucial because if the Second Circuit had solely considered the late 18th century, it would have had to concede that no historical tradition supports the CCIA. CCIA, too restrictive. Critics are voicing concerns over the perceived stringency of the recently enacted law. To recap, shortly after the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin, the New York legislature swiftly passed the Concealed Carry Improvement Act. The law in question, central to the Bruin case, mandated that individuals seeking to carry concealed handguns outside their homes must demonstrate proper cause for a license. New York courts interpreted this requirement as necessitating more than a mere desire to safeguard oneself or one's property. However, the Supreme Court, in a 6-3 vote, deemed this scheme unconstitutional. In September, a coalition of gun owners approached federal court to contest the CCIA, asserting that the state had disregarded the Supreme Court's Bruin decision by implementing an even more restrictive system. In November, U.S. District Judge Glenn Sotheby sided with the challengers, restraining the state from enforcing several critical aspects of the CCIA. These included mandates for applicants to demonstrate good moral character, provide family members personal information, impose firearm bans in designated sensitive places like churches and parks, and restrict firearms on private property without explicit consent from the owner. In another case, arms and ammunition dealers holding federal arms licenses contested the stringent requirements imposed on them to conduct gun and ammunition sales in New York. These state-imposed restrictions entail storing firearms in locked fireproof safes outside of business hours, installing comprehensive security systems, providing state police-approved training to employees, conducting monthly inventory checks, granting state police unrestricted access during inspections, prohibiting minors from entering their stores unaccompanied, and only hiring individuals aged 21 and above. The plaintiffs argued that complying with these regulations would force them out of business, thereby depriving their customers of the Second Amendment rights. However, the Second Circuit dismissed their claims, stating that the plaintiffs failed to demonstrate that New York's laws posed such a significant restriction as to jeopardize citizens' rights to acquire firearms.
I hope the whole system dies. Let me be brutally honest.
The law has gone into effect across New York, making gun owners worried it's going to only affect small business.
It took 8 hours between a computer tech and me playing with their website to get their website working. This, I think, would just kill anybody's notion in having a family-type gun shop.
You know, the inner city and our problem is illegal guns. And, I constantly say illegal guns start out legal somewhere. Great, you want to protect your family, that's all great, but we just want it to be as safe as possible.
I don't know how effective this is going to be, certainly.
Furthermore, the appeals court ruled that New York's regulations were not preempted by federal law, as they did not directly conflict with federal firearms regulation. Additionally, the appeals court concluded that the plaintiffs lacked standing to pursue individual claims regarding certain provisions of the law. These provisions include the requirement to obtain a license to own semi-auto rifles, undergo background checks for purchasing ammunition, and undergo training to renew concealed carry permits, as they alleged violations of the Second Amendment. On December 7th, the U.S. Court of Appeals for the Second Circuit granted the state's request to suspend Sotheby's order pending appeal. This development prompted the challengers to petition the Supreme Court 2 weeks later, seeking to reinstate Sotheby's ruling. Need some air. In a 28-page submission to the justices, the challengers argued that the provisions of the CCIA suspended by Sotheby significantly impede obtaining a license to carry a gun in public. Moreover, even if an applicant manages to secure a license, they contended that the law effectively prohibits carrying a gun in most places. Consequently, they asserted that the new law blatantly defies the Supreme Court's decision in Bruin, which elucidated that the Second Amendment safeguards a broad right to carry a handgun outside the home for self-defense. The state countered that the good moral character requirement has long-standing precedence and is not a substitute for the proper cause requirement invalidated in Bruin. Additionally, it questioned the standing of the challengers to bring forth the lawsuit. 5 of them already possess carry permits, fulfilling the good moral character criterion, while the 6th challenger has never applied for a carry permit. Nonetheless, the state urged the justices not to intervene at this stage. Instead, it advised waiting for the Second Circuit to rule on its appeal, which is expedited, and for other lower courts to apply the recent Bruin decision. The justices declined the challengers' request without providing an explanation, simply indicating that the request was denied. Highlighting that the CCIA raises novel and serious questions concerning both the First and Second Amendments, Justice Alito's statement criticized the Second Circuit for its failure to provide any rationale for suspending Sotheby's ruling while the litigation progresses. Alito clarified that the court's denial of the request today reflects deference to the Second Circuit's docket management rather than a stance on the case's merits. However, he stressed that if the Second Circuit fails to promptly justify its stay order or expedite the appeal process, the challengers have the option to petition the Supreme Court to reinstate Sotheby's ruling. The upcoming Supreme Court conference on June 6 regarding this case could have significant repercussions for similar laws across other states, including California. New York contends that the Supreme Court should refrain from reviewing the case at this juncture, citing concerns over standing and preliminary nature of the injunction.